Good afternoon. Myself, Dr. Kaneez Fatima, Faculty of Judicial Science, Rama University. Today, my topic is intellectual property rights and style. Intellectual property rights, its IPR, means the legal rights given to people for their creations of the mind. These creations can be inventions, books, music, designs, logos, brands, etc. And new technologies is the IPR. IPR helps creators and inventors to protect their ideas from being copied or misused by topics. The main purpose of IPR is to encourage to new inventors, creativitors, and innovation by giving exclusive rights of the creators. It also helps in economic growth for competition and development of society. In this presentation, we will understand the meaning of intellectual property right and its type, such as a patent, copyright, designs, and its importance in the today knowledgeable sessions based on economic. First of all, what is the intellectual property? Because intellectual property refers to creation of the human mind that are given legal protection so that creators or owners can control, use, and benefit from their work. Simple definitions in the IPR only. Intellectual property is a legal right granted to a person over their ideas, inventions, artistic work, symbols, logos, etc. So its user designs, business and creations and creative activities. That's its features. It is an intangible but not physical like land or goods. IPR, IP, yani, it means intellectual property, only a intangible property. It protects original ideas and creativity. It gives exclusive rights and it's a limited period given us. It encourages innovation and creativity. That's next is my what is intellectual property? What is intellectual property? Intellectual property right, it means refer to the legal rights granted to creators or owners over their intellectual creations, allowing them to use and to creative and to control and to commercially exploit this. Intellectual property rights are their exclusive legal rights given to a person over the creation of their minds, invention, literary and artistic work, symbols, names, and designs in commerce. What do IPRs protect? It means IPR protect which creations? IPR protect intangible creations, including inventions, literatures, books, brands, names, logos, industrial designs, traditional knowledges, etc. Purpose of IPR to encourage innovation and creativity, to reward access the creators, to prevent unauthorized use or copying, to promote economic and technology development. Next, difference between intellectual property and IPR. Intellectual property between IPR, intellectual property rights. Intellectual property not to be confused with IP, and it is right vested the asset, not the asset itself. Intellectual property is a idea or IPR, intellectual property right. Invention is a patent registered in an IPR. A customer, a price list is IP. A right of confidentiality is an IPR. A secret production method is IP. But a right to trade secret is IPR. A particular way of representation is IP. But copyright or a design registration is IPR. A brand, a trade name is IP, and trademark registration is an IPR. That is a difference between intellectual property and intellectual property rights. Next, main branches of intellectual property rights is a industrial property and a copyright. Industrial property is a patent, industrial designs, trademarks, trade secrets, plant secrets, integrated circuits, geographical indications. But copyright is a literary form. Literature, novel, poem, plays, films, musical, artistic dramas, drawings, photographs, performing art, sculptures, and software, etc. It is a copyright and it is a industrial properties. So both are different, and two branches is an IPR. Next is the main types of intellectual property. Main types of intellectual property is a number one, patent. The Patent Act 1917 as amended in 1999, 2002 and 2005 protect invention, new products or process. Example as a new machine or technology. First patent is a pankha pulling machine. That the Copyright Act 1957 is amended in 1983, 1984, 1992, 1999, etc. Protects Copyright is a protect literary, artistic, musical, and dramatic works. Example, books, songs, films, softwares, etc. Third type is a IPR. It is a trademark. The Trademark Act 1999 protect brand identity. It is a brand identity as logos, brand names like a Nike, LG, like a Godrej, etc. Next is a industrial design. Industrial design is also a main type of intellectual property. The Design Act 2000 protect the aesthetic appearance of product as a shape and design of the bottle. Designs of the bottle and design of thumbs up bottles, Coca-Cola's bottles, etc. Next is a geographical indication, and the Trademark Act 1999 protect products linked to a specific place, as are Darjeeling tea, Banarsi sari, etc. Next is a trade secret. This is a protect confidence business information as a Coca-Cola formula. As an example is a Coca-Cola formula, etc. Next types of the IPR is plant varieties. The protection of plant variety and Farmers' Right Act 2001. Specific is a plant varieties, plant rice, basmati rice, as an example is a BT cotton, as an example is a hybrid wheat varieties, as an example is a haldi products, as a neem products, etc. etc. Next, today is an introduction of the patent. Patent is a compliance with international obligation TRIPS agreement. The Patent Act 1970 has undergone three amendments: 1999, 2002, and 2005. The third amendment in 2005 has major implication on the following. Number one, introduction of product patent protection for food, pharmaceuticals, and chemical inventions. That is the examination of the mailbox application from January 1, 2005. Next is a legal title granting its a holder the exclusive right to make use of an invention for a limited area and time by stopping other form, making, using, or selling it without authorization. In return for this right, the application must disclose how its invention works in sufficient details. When a patent is granted, the applicant becomes the owner of the patent. Like any other form of property, a patent can be though sold, licensed, and mortgaged. Patent are territorial rights, so an Indian patent will only give the owner's right within India and rights to stop other from importing product into India. Next is the patent law and practices. Is that as a patent office, so inventor and assignee of the inventor. This is the 20 years exclusive right on advancement in the patent. Next type is the copyright. Copyright, India has a very strong and comprehensive copyright law because Indian Copyright Act 1957 implemented 15 January 2000. The amendment in 1994 were a purpose to technological changes in the means of communications like broadcasting and telecasting in the emergence of a new technology like computer software, etc. 99 amendments have made the Copyright Act fully compatible with trade-related aspect of intellectual property right. It is the TRIPS Agreement. TRIPS Agreement amending the law has made provision for the first time to protect performers' rights are envisaged in the Rome Convention. With these amendments, the Indian copyright law has become one of the most modern copyright laws in the world. Copyright covered this types of the IPR. It's the original literary, dramatic, musical, and artistic work, computer softwares, originals, engineering drawings, cinematographics films, and sound recording. Then, copyright right to reproduce, make, copy, adaptation, and translation applicable. It is a term usually lifetime to the other author until 60 years following the year of death of author. Broadcast reproduction 25 years, perform right 15 years, author's rights, moral rights, authorship, objects of alteration, rest and share right in original copies. This means the author's right is a 25 years, performer, then lifetime is a only authorship of the copyright. Next is the trademarks. Trademark governed by the Trademarks Act 1999 is a trademark is a sign which distinguishes the goods of one trader from those of another. Sign includes as a words, logos, pictures, or combinations of these things. A trademark is used as a marketing tool so that customer can recognize the product as a particular trader. As an example of the Nike, example of the Limca. Trademark is a registered trademark, distinctive and not deceptive or contrary to law or morality, and non-identical or similar to any earlier marks for the same or similar goods. Is that fanciful marks? It is an example of the trademarks. As a Kodak, arbitrary marks is an Apple for computers, suggestive marks give hint of the product, as a baby dairy for nappies, etc. etc. It is an example of trademarks. Next is the protection of new varieties of the plant. Is that clear of the protection of plant varieties and farmers' rights 2001? Is that the objective of this act to provide for the establishment of an effective system for protection of plant varieties, to provide for the right of farmers and plant breeders, to stimulate investment for research and development and to facilitate growth of the seed industry, to ensure availability by high quality seeds and plants materials for improved varieties of their farmers. Next is the type of the IPR is a layout designs. The Layout Designs Law Act 2000 implemented the 2000. This is the semiconductor integrated circuits layout design is the govern of the layout design of integrated circuits in India. The name of the act is to provide protection of IPR in the area of semiconductor integrated circuit layout design and for matters connected therewith or incidental thereto. The Semiconductor Integrated Circuits Layout Design is the register of the Department of Information Technology and Ministry of Information Technology. Next is the Design Act. It is a designs. The existing legislation on industrial design in India contained the new Design Act 2000. India had achieved a major status in the field of industrial designs and in view of globalization of the economy. Next is a Geographical indications governed by Act 1999. Geographical indication of good Registration and Protection Act 1999 is amended 15 September 2003. The source of geographical origin of the biological material used in invention and required to be disclosed of the specification. It is an example of the geographical indications are a Darjeeling tea, Kanchipuram silk sari, Alfonso mango, Nagpur orange, Kolhapuri chappals, etc. Next is a trade secrets. Trade secrets is a typical example of Coca-Cola. This soft drink was invented in 1886 for the never protected by the patent, only by a trademark. So, the process of the Coca-Cola drink is a secret and is only known by two persons. The word, they are not allowed to travel together so that there is no chance of them dying at the same time in accident. The secrets of the Coca-Cola process was well kept during all these years and nobody is able to produce a drink with exactly the same. Next is a trade secrets is a confidential information. So, not disclosed to others. Keep it secrets and not disclosed to others. Its characteristics is a confidentially information, not generally known as reliable, and what they protect is this: process, techniques, methods, customers lists, business strategies, etc. How they differ from other IP? Patent, public disclose for the limited time, trademark, protect brand names, logos, and no registration, no forward feeding, but protection ceases upon public disclosure. It is a trade secrets. Instruments, advantages, privacy, confidential, formula, data, and intellectual property rights, etc. Thank you.